Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning, everyone. Welcome to the Florida Supreme Court. We have an interesting docket of cases this morning which deal with court procedures. I know that the lawyers that are here today to discuss those cases are going to be especially educational about our rules. So with that, we'll go right to the first case. Amendments to the Florida Rules of Civil Procedure. Council's ready. You may proceed. Pause now.
I'll sit down. Thank you.
Okay, thank you. Mr. Graves, Mr. Frieden, Mr. Graves, you're going to go first, and you all are going to have 10 minutes each. Is that your agreement?
Yes, sir. Thank you.
Okay, Mr. Graves, good morning.
Good morning. If it pleases the court, what I hope to do is to convince you, if you're not already convinced, that requests for admissions are perhaps the most powerful pretrial discovery tool that we have. And if anything, rather than limiting the number of admissions permitted to the people of our state to get at the truth before they have to go to the expense of trial, that we would ask you to clarify the confusion that exists over the use of admissions, give us a clearer idea of where the line is that we should not cross, and deal with the fees issue that the Bar Committee is concerned about, which I can see that's a legitimate problem because you have this
Tell us where we are now and where you would like
Well, where we are right now is that we lawyers have to deal with the rules as they are written. And Rule 1.280, of course, says that I'm allowed to get discovery of any matter that's not privileged by several different methods, including request for admissions. When we turn to the rule itself, it says that I'm allowed to require the other side to admit the truth of any matter within the scope of 1.280, and that's a very powerful thing to be able to do. In fact, it's in the form of a leading question, which I cannot do with interrogatories. And
Counselor, are you suggesting that there should be no limit on the number of admissions in the rule?
No limit on the number, Your Honor, but rather a limit on the use. There are two kinds of lawyers, please forgive me. There are the lawyers who seek the truth and the lawyers that seek to hide it. I can't think of a better way to get at the truth than to require the defendant or the plaintiff in a case to admit that he owned the vehicle, he was driving the vehicle at the time of the accident, or whatever it might be. These are not complicated things. They're very efficient. It's either yes or no. It doesn't take forever to answer.
Well, the bar's proposal doesn't eliminate the use of requests for admissions. It just says they're limited to 30 unless you can stipulate to more or you get permission of the court. What's wrong with that?
Well, one of the things that's wrong with it, Your Honor, is the reasons given. Now, the reasons given don't make sense to me, and forgive me, but my colleagues in Stewart actually chuckled. Everybody in my office thought it was funny, and the president of the local bar thought it was somewhat ridiculous that we would argue to reduce the number of admissions because, oh my goodness, people are using them for discovery or to prove the elements of their case. Well, that's what it's for. The rule specifically states, if I may, the purpose of the rule is to expedite the trial of the action, relieve the parties of the time and expense entailed in proving the genuineness of documents or the truth of matters of fact, which can be ascertained by reasonable inquiry.
Look, I agree with you completely that that's one of the purposes of request for admission.
Surely.
It's also the purpose of interrogatories, but we limit interrogatories to 30 unless you get permission of the court.
But the time required to answer admissions is nothing compared to the time to answer interrogatories.
We're not talking about time, we're talking about number. So what's wrong with saying 30 or 50 or 60 if that's the problem, but having some limit unless you can stipulate with opposing counsel or get permission of the court?
Well, what I would ask the court to consider would be a rule or an order that would clarify for us what is excessive. not in terms of a fixed number. For example, I have a case now in West Palm Beach. It involves 6 defendants, 4 individuals, 2 corporations, the theft of a very large investment business, very complex issues. I need more than 30 admissions, but the court may be disinclined to create any more work for itself than necessary. What I would argue is if someone files more admissions than necessary, well, then the court could rule that that was something that might be dealt with.
Why,
But the argument here that it's,
why isn't the analogy to the interrogatories, is it correct that the interrogatory rule limits the number of interrogatories to 30 unless there's a stipulation or permission by the court? Is that correct?
Your Honor, interrogatories are typically direct questions that require lists of information, as you know, the name and address and so forth and so on and so forth and so on. Very detailed answers rather than yes or no. It's either true or it's false. It's not as complicated as an interrogatory.
But it's much more sophisticated than that, is it not? That is, because of the consequences of an answer to request for admission, as you say.
Yes, sir.
Consequences can be dramatic in that respect. But why not, if you're going to have that requirement in the interrogatory rule? Trial judges now just complain of the excessive amount of time that they have to spend policing the discovery process in the civil courts.
Yes, sir. I think that perhaps that's because a number of lawyers, including some that I've had to deal with, cite that's from the 1971 City of Miami versus Bell case that has been changed. After the Rules Amendment in 72, it was no longer objectionable to ask for admissions of elements that go to the heart of the case. That was changed. It was done away with. There's a progeny of cases that follows that. There's a recent case, the arena parking case, where the courts have said, no, this is okay, you can do this. And why shouldn't we be able to do? Why should I not be able to cause the other party to admit facts before trial rather than putting these poor people that cannot afford to pay legal fees to go to trial?
Interrogatories, does it not?
No, sir.
It doesn't?
A request for admission is a leading question. An interrogatory is not. It's in the same form as a leading question. We all know that's the most powerful way to get at the truth. All I want to do is to be able to go after bad people who have done bad things, make them admit that they've done them before I have drained my client's pockets dry. So we get some clarification from the court as to what is extreme, what is excessive, rather than limiting this very powerful due process right that belongs to the people of the state of Florida.
Isn't excessive, though, virtually always going to turn on the circumstances of the individual case?
I would suggest that proper use of admissions could probably save the state millions of dollars by getting cases settled before trial, and that is the purpose. But just to add one more thing. The rule comment says, one party may not obstinately put the other to his proof. And yet I submit to you that this is commonplace, at least in the 4th DCA where I practice. It is commonplace.
So you have no limitation on the number?
There has not been before this. I don't see that there should be after this. And above all, I would ask the court, if you're inclined to limit it, then require the Rules Committee to give you a better excuse than some people are using it for discovery, because I have the book, and the book says that's what it's for. That's not a good reason to amend it. If you want to amend it for some other reason, let them come up with a better reason.
Thank you.
Thank you, sir.
Mr. Frieden.